Mr. Hermer, I feel we should say, first of all, that your side is completely exonerated. The supplementary note was received in the RCJ last week, but through administrative oversights did not reach my desk or my ladies. So the apologies are due from this side, not your that.
Well, not at all, my lord. You notice I've already veered somewhat off the
So we
strict
need the
terms of that
anyway.
note anyway. But thank you very much. That'll be a relief to those that sit behind me.
Yes. We still don't know why Miss Webb didn't get it, but that's between you and her.
I'm pretty sure the mistake there, so you've got it, is that it went to my learned friend clients. I think.
Yes. Okay. Well, they couldn't matter less.
I'm sorry for
yeah.
that.
No. Let's get on.
Could I start with my own apology? I mangled the description of the facts in DSD, a point that I think my lady picked up. I think I had said that in respect of both claimants, there was a breach of the pre-rape obligations. And there is, as the paragraphs to which my lady identified at 24 to 27, a distinction between the two cases. So DSD, any failures in the investigation were not causative of the rape, but a failure of DSD's own investigations should have led to the apprehension of war boys before NBV's rape. I'm sorry, I didn't accurately portray that. I'm going to, in response to the Vice President's request, touch briefly in a moment on the question of morals damages, but I'm afraid it's not going to be comprehensive. And subject to the court's view, there's a Law Commission report, and this is entirely my mistake, isn't before the court on the scope of damages under the Human Rights Act, which I haven't had a chance to consider. But I would ask if the court thinks it would be of assistance, rather than do it on the hoof, although I'm going to show you one bit from Alsaran in a moment, if it would be of assistance to be given leave to do a short note.
I think that probably would be helpful. On the whole, as you will know, we don't like short notes coming in after the hearing. On the other hand, on a difficult point of this sort, and it will only go to the background, if it was at the centre, we would want a situation where there had to be lots and lots of notes answering each other and so forth. But I think it would be useful background.
What's the Law Commission report?
It's a Law Commission report from 2000 on damages under the Human Rights Act. And a very quick search does show that they at least refer to moral damage. And I wouldn't want the court, if it does contain relevant material, I wouldn't want the court to be in a position of not having been furnished it by the parties.
Yes. Well, I asked that question because it was a phrase used in a particular judgment. You showed us a lot. It may well be that the argument has moved on, but maybe it hasn't. So let's as a precaution say, yes, you can put in a note, well, uncontroversial nature, just as far as you can, showing us, preferably agree it with Ms. Webb first, bring us a link to the report and the relevant passages and saying what, if anything, you say comes out of them.
Yes, of course.
How long would you need to do that?
7 days, my lord.
Do you need as long as that? I mean, if we're right and we're going to finish today, we're going to have half a day off tomorrow. I mean, it's just the court quite likes to get going on this if it can. So I'd have thought by the end of the week.
Of course.
My lord, I don't mean to interrupt inappropriately. I just wondered if it made sense to flag CICA's request in terms of the supplementary note. So my learned friend's absolutely right that it was served on the CICA, but I haven't seen it previously. So one way forward, if you're happy with this, would be for us to finish submissions as much as possible today, but for us to reconvene briefly tomorrow morning in case there are any further points arising.
You have obviously been, you hadn't seen it, and we wouldn't want to put you under any pressure. If that's the way you'd like to deal with it, that's how we'll deal with it.
I'm very grateful.
It might make sense to rise a little early. We'll look for a natural break, but if a point comes where you feel I'm just exploring it. I think that probably is the best way forward. It's the one that you've suggested. If you would rather I haven't discussed this with my lord and my lady, as it will rise for the rest of this afternoon and sit tomorrow, but that might mean we're a little bit short of time. I probably wouldn't.
My lord, very happy to present my submissions as planned in broad terms, but there may be some points, given the way things have developed this morning, which...
Look, we will be very flexible if there are points you feel you need more time to think about because of unexpected way in which the case has gone. So let's just leave it like that.
Thank you. And the point to stand at this juncture is simply in case that Law Commission report can be dealt with tomorrow morning in the same way. But
oh, I see. Yes. Okay. Well, let's see how we go.
So I was developing four very short submissions.
Yes, you were.
But just to be clear, they are in response to the authority's interpretation of paragraph 49.
Yeah.
And the first one was it doesn't accord with the plain reading. My second point is it doesn't accord with what we say is the purpose of paragraph 49, which is simply to prevent double recovery. It goes far further than that.
Yeah.
My third point is that their reading wouldn't be compliant with convention rights, because its effect would be, in very many cases, to deprive a victim of a breach of Article 2 of any compensation. So that somebody whose loved one was murdered in circumstances in which there was a failure to prevent by the state would receive no more compensation than an individual who received compensation under the scheme with no state fault. And that, consistent with the authorities I showed the court this morning, would not give effect to the appellant's convention rights. That's not just a question of Article 2 and Article 13. Insofar as they are taking money back from an individual that was not justified by a clear policy rationale, such as the need to avoid double recovery, the expropriation of those funds would be an unjustified breach with the appellant's article.
Well, does that add anything? There's no circumstances in which the A1P1 argument would add anything to the points you've already made, would it?
No, it just reinforces the points, I think. I mean, if I was up against...
Also, whether it would apply if it was the other way around, because where if the award had come first and it was being suggested that CICA should pay you less as a result.
Yeah.
Anyway.
I mean, if I was up against it, my lord, and there was compelling arguments inuring in favour of a broad power, not just to avoid double recovery, but to take unrelated funds, as has happened here, then I would develop at a bit more length the freestanding nature of both the Article 2, need to comply with Article 2 and how it doesn't, and Article 1 of the first protocol, because they're slightly different.
Well, I don't want to cut you off.
No.
At the moment, it doesn't seem to me it adds anything. But if you think it might, and you want to develop it,
well, there are just two ways, my lord, in which the reading contended for by the authority would not be compliant with convention rights. And if you're faced with two competing interpretations, one of which is convention compliant, one of which is not, then Section 3 requires you to give a convention compliant reading. My fourth and final point is that the approach, or the interpretation contended for by the authority, is inconsistent with the approach of civil courts take when they seek to take account of an award from the authority, whether granting damages under common law or under the convention. And I've already identified that that may have some significant implications were it right. Not least an inflationary impact on Article 2 damages in order to secure that after recoupment beyond double recovery, a victim of a convention, a breach of a convention right, received appropriate just satisfaction. And again, that inures against the authority's interpretation and in favour of the appellants. This is just a simple rule about avoiding double recovery. My lords, my lady, those are the submissions that I was going to make under the third part of the appellant's case. Could I turn to the fourth and final, which is to turn to the question as to whether or not there has in fact been double recovery in this case, and how the appeal in our respectful submission should be disposed of. Can I make 8 bullet points, please? The first is that there's real difficulty in answering that question because convention jurisprudence is opaque when it comes to identifying the constituent elements of an award for an indirect victim under Article 2, let alone the relative values to be accorded to those components. It was a point highlighted by Mr. Justice Green in the DSD case at paragraph 9 of his judgment, page 680, tab 18.
Sorry, I've been slow here.
So it's page 6,
Yeah.
80. I'm sorry.
Para 9.
Para 9.
Yes, thank you.
Certainly within the materials before the court in the authorities bundles, the most helpful breakdown, certainly of principles that go into making an award, is provided by Mr. Justice Leggett in Alceran. That's same bundle, tab 22, para 908 at page 885. The main heading section is actually at 904, where his lordship, under the heading Damages under the Human Rights Act. But his lordship turns at page 908 to the practice of the European Court and identifies a number of principles and components of damages awards. Could I pick it up at the fourth of those principles, because this is where his lordship turns to non-pecuniary loss under the convention. And could I ask the court, please, to read through to paragraph 916.
Sorry, starting where?
Starting at 912, my lord, through to 916.
In 908 refers to a practice direction issued by the President of the Court in 2007 on just satisfaction. Do we have that, or is it? We do.
Yes, my lord, you have that. Tab 32. At tab 32 at page 1341.
But it doesn't say anything
I'm not sure my lord's going to get more from that than you are from Mr. Justice Leggett.
Sorry, you told me already, 912.
It's 912 through to 916, my lord. Can I draw a few things out of this, if I may?
Yes, it's not a criticism of Mr. Justice Leggett, but rather of the material he was having to struggle with. That there are bits that I still don't find very easy to follow, but let's see, no doubt by the end of your points I will.
Could I start with 912? So in terms of non-pecuniary loss, and it sets out the type of impact on the individual that would be covered by that, such as distress, anxiety. That's also a category into which grief, we would say, would naturally fit. But that appears to be separate and distinct, or at least capable of being separate and distinct from moral damage.
Hang on 1 second.
So separate and distinct from moral damage, which his lordship turns to at his 6th point. And drawing from the passage in Varnava, and also you'll see the citation there to the passage in Al-Jadid, to which I took you.
Substantially identical, as they often do.
As it often the case,
Yeah.
substantially identical. Moral damage cannot be readily equated to non-pecuniary type of harms, such as grief. It's something intrinsic in the nature of the breach of fundamental rights. And it may be thought that the language of moral damages is in this context particularly well suited to a human rights instrument. And the moral impact of an infringement of your fundamental rights and the need for that to be recognised. But there is clearly in our submission a component, at least, of the award that you will get from Strasbourg that is in addition to the suffering that you will have, your human suffering by virtue of the breach itself. And that is reinforced by the fact, if one then turns to his lordship's 7th point, that you can take account of the conduct of the state.
Well, can we come back to that in a minute?
Yes.
Just 914 does shed a little bit more light on concept of moral injury, because in the first of the extracts from Varnava, which I don't think is reproduced exactly in Al Jeddah, there's talking about impact on the moral well-being of the applicant.
Yes.
So it's clearly regarded as a loss suffered by the applicant. It's not in any sense simply declaratory or punitive, or it reflects an injury that they have suffered of what this describes. And one sees that again from another passage, which I don't think we saw in Al Jeddah. Hang on one second. No, I'm imagining something that isn't there. But in any event, it's clearly an injury to the applicant. So it's,
My lord, my submission would be that one should. I'm so sorry.
Sorry, I've just remembered what I wanted to ask. Which he says in the first of those extracts, the Grand Chamber says the impact of the violation may have impinged so significantly on the moral well-being of the applicants to require something further. Do we know something further than what? We probably would know if we looked at Varnava. We haven't got in the bundle, have we?
No.
Does it mean something more than a declaratory relief, or does it mean more than merely distress?
I'm so sorry, my lord. I can't give you
No,
an accurate answer to that.
Well,
That's
I
my
might look
fault.
for
and I
myself
would-
later.
yes.
But yeah, thank you. Sorry.
But can I seek to draw a distinction, my lord,
Yes.
between what the court means when it addresses distress, the normal types of non-pecuniary damage? I mean, firstly, when it refers to moral damage, it must be referring to something that is distinct from that.
So ordinary distress contrasted with moral damage.
Yes.
Ordinary distress of legal
Yes.
grief.
And that is best explained because we are not in, as the court emphasises, we're not in a common law or civil law system of compensation. This is breaches of constitutional rights,
Domestic tort mechanism.
not a domestic. Yes. And so it's something more. So we know it's something more than merely grief, and it's of a different nature. And in absent any clear expression from Strasbourg's particularising what that means, one comes back to first principle. And first principle must be that there will always be moral damage if your fundamental rights are breached by the state.
That's not, some of the cases talk about you don't need damages. Sometimes a declaration will be enough. Feels like to get into moral damages, that needs to be a sort of sense of outrage or something a bit more than.
Well, it's certainly not. Well, we can work that out perhaps by way of silhouette, because we know it's not exemplary damages, because we know that's not allowed. We know, because his lordship goes on to it, it's not aggravated damages. They are reflected, but that's not what moral damages refer to. There are some breaches of the convention that we have seen, and Article 6 is the classic one, in which you would rarely need just an award of compensation, because what you're trying to do is rectify an unfairness, and if the court grants you a declaration or makes an order, you're going to achieve that. There's no need for compensation. But there are some rights, particularly that go to the fundamental dignity of humans, and Article 2 and Article 3 are obviously key, that are so important that when those rights are breached by the state, you're going to be deemed to have suffered a moral injury. So we know it's distinct from grief. We know, as I'll come on to, that it's not going to have an analogue under the CICA award.
It's a very odd phrase, but to me, moral means to do with right behaviour. But it clearly means something quite different here, but I don't know what.
Yes, and that's why, my
I
lord,
think really what you're saying is it is the label used, even if it's civil law English rather than ordinary natural English, to mean that conceptually, if your fundamental rights have been breached, that is an injury to you, whether or not you happen to be upset by it.
yes. And my
Or that from that it would follow that moral damage was suffered in every case. But as my lady pointed out, that isn't what the case law says. Even the passages here don't say that. I mean, what Lord Justice Leggett, Mr. Justice Leggett, was saying was sometimes it won't just be the anxiety and distress; it'll be the moral damage as well. But if that's the case, I don't quite understand that, because if it means what you say it means, moral damage will always be suffered.
But it doesn't always need to be reflected in an award of compensation.
Yes,
so
I
if we're in the territory of Article 6,
Yes, I
it
see.
doesn't need to be compensated.
So your distinction is, I'm sorry if I'm being slow, but it's a tricky area. You say on the construction you're putting forward, there will always be moral damage if your fundamental rights are breached. But it is a separate question whether a pecuniary award should be made for that moral damage. Sometimes it will be, sometimes it won't be, effectively depending on how severe the moral damage is. Is that right?
Yes, albeit in the context of Article 2, my submission would be it would always be made.
All right, but forget Article 2 for the moment.
Yeah.
Just conceptually, there will always be moral damage if your any of your convention rights are breached, but it will require a certain level of severity for you to be entitled to a financial award for that moral damage. But one of the cases in which that will, you say, always occur is Article 2.
Can I answer that with a yes, but could I slightly tweak it? Because what we don't benefit from is help from Strasbourg or domestic courts as to that precise point. What we do know is that there will be classes of cases in which, although there has been a clear breach, the court has concluded that there's no requirement for just satisfaction to be by way of damages.
Yeah.
Now, correct if I'm wrong, but I don't think in any of those cases has the court gone on to say, but you still suffered moral damage, but for these reasons we're not compensating.
No,
It's
but I
dealt with it
thought
on a
that was
more-
what your position. I thought your position was that moral damage is what you call it when your fundamental rights are breached.
Well, yes, but those are submissions that are advanced through the prism of Article 2, and it would apply equally to Article 3.
Okay, so
Because
would you like me to qualify
they're
it?
unqualified rights at the very heart of all about personal dignity. And there it would be very hard to see how one could conclude, in which the authorities say you're going to require to be compensated. And it would be very hard to see how there couldn't be in an Article 2 case a component of award that reflected the fact that your fundamental rights have been breached, and that could aptly be described as what moral damage is. Now, there may be circumstances on particular cases that moral damage will be a greater component than others on the facts, but if you're in Article 2, you're going to get a component, in my respectful submission, that includes moral damage.
Am I right in saying there isn't a case that tells us that? That's a submission, that's an assertion of submission on
That's a submission.
It should work that way, and it does work that way.
Well, I can't. There's very little for me to say it does work that way because we don't have the cases, and you don't have evidence as to how the case is
No.
settled. But
But
we're
you,
in a
you get some of the way there from the various passages drawn together by Mr. Justice Leggett.
yes,
They're not explicit, but it's a way of making sense of things he does say.
my lord, that is my submission, and I mean, it's not based on a wish list. It's rather what we would submit is the application of basic convention principles.
But how does this fit in with some of the passages you referred us to this morning, in particular the from D in the Supreme Court? The award of compensation is geared principally to the upholding of standards.
Yes, well, my lord, that
This is a much more English-style analytical approach, which seeks to divide it up into, rather than that sort of overarching, what's it principally geared towards?
well, my lord, that in my respectful submission, it supports my contention because the way that I've sought to describe moral damages fits in with the emphasis about the purpose of these protections. The purpose of compensation is to uphold values. And at the heart of what my submission, moral damages, rightly construed is all about that. And it all goes to my overreaching point, is that you can't look at the £10,000 here given by way of award for Article 2 and say that all or most of it reflects grief. There are going to be all sorts of components as part of that £10,000. The grief, the moral damages, and insofar as that doesn't reflect the need to vindicate rights, the vindication of rights, and the behaviour of the defendants, of which grief is only one component of is the only shared component of the CICA award. That was the first and longest of my eight points. The second is the opacity.
Sorry, I'm going to make it even longer, but
course.
just by a request for someone just to look this up. I'm quite interested by Mr. Justice Leggett's observation at the end of para 915 that the way you take into account the state's conduct is similar to the English law concept of aggravated damages discussed earlier. Could someone just look up the reference so we can look up for ourselves for where he discusses aggravated damages earlier? So
Yes,
I
of
do
course.
know that aggravated damages are themselves a very tricky area. And so I'd quite like to know what Mr. Justice Leggett thought they meant.
Yes, of course.
Yeah, thank you.
Can we add that to the note that we'll circulate by the end of the
Yes.
week latest?
Thank you. Yep, do go on.
So my first point was about the opacity of the framework for quantifying damages under Article 2. My second point is that opacity is even more marked in respect to the CICA scheme. I've already developed submissions that the only possible overlap in this case could be the 5,500 bereavement award, but there's nothing within the scheme nor any associated guidance telling us precisely what the bereavement award means.
Yes.
And whether there are different elements to it.
But that does perhaps come back to the point I floated beforehand, that it would be a natural assumption that it's meant to be the same as a bereavement award at common law as introduced to helpfully now established in 1983. And I think that would be my starting point, because broadly speaking, the scheme is intended to mirror with certain modifications what you would get at common law. And I still think it might be helpful, therefore, possibly a third short element for the note, if there's any definition either in the case law prior to the 1983 Act or in the materials associated with the introduction of the 1983 Act to say what bereavement is meant to cover, because I would start from the position that's what it also means here.
Yes, of course we'll do that. I would urge a little caution in drawing into a statutory scheme that has certain aspects of it that are quite markedly different from the common law. A purpose and intent from the award under the 1976 Act between the award given under the scheme. My lord, I wouldn't go so far as to say the court would gain no assistance from it, but they're serving two very different purposes. I mean, one is vis-a-vis between rights of private individuals under private law. The other is a statutory scheme to compensate for where no one is at fault, or certainly no one who's paying is at fault. And there are some marked differences.
I do absolutely get that.
We'll address it.
But having said all that and aiming off for it, I think the starting proposition, the concepts are probably used in the same way.
Yes.
The two. I mean, they didn't have to give something for bereavement, but once they do, one would think they had in mind the common law concept. There you are.
My lord, we will certainly
Have a look, see if there's anything about that. There may or
we'll see
may
what we
not
can
be.
find, of course. But my basic point is that there is no clarity within the scheme or any associated guidance that tells you what the bereavement award is, whether it has individual components within it, and or any weighting.
What do you mean by
I
weighting?
suspect that, well, I was about to say weighting as between those different components, but actually, as I say that, that's a bad point because there's a single solitary award.
Single dollop, isn't
It's
it?
a single dollar, yeah. That's a bad point. Can I move to my third point? As a matter of principle, I've already accepted that insofar as there are elements in the non-pecuniary award under Article 2 and in the statutory award for bereavement that compensate for the same thing, and here we would identify grief, then that would be capable as amounting to duplication and that paragraph 49 in principle is engaged. My fourth point is that there can be no duplication at all between that Article 2 settlement award and the £20,000 awarded for loss of parental services. I've shown you how they're calculated in the scheme, and I've also shown you the claim letter in which that type of loss was expressly eschewed. It was set out in a schedule as a type of loss that was sought, and then the claimants made plain that all they sought were non-pecuniary losses, so it didn't include those type of losses. And so there's no way that it can be said that this £15,000 incorporates to any degree an overlap with loss of parental services.
Is there? It does have a faint echo, and I'm afraid I can't tell you of what, but of situations where parties tactically put awards under one head,
Yes.
characterize them in a way which does not reflect the approach that a court might take in the same situation, in order to avoid, maybe a tax consequence, I don't know, in order to avoid overlap problems. So should we necessarily simply accept the fact that the £10,000 was in the claim letter or the schedule came under the heading non-pecuniary losses, that it was purely for feelings?
Yes, my lord, because what you get in the correspondence is the starting point, which is a claim both under the HRA and also under common law. Under common law, you will see a load of headings for pecuniary losses. You then get the position, which is the denial of liability from the defendants, and effectively an offer then from the claimants is, okay, we will restrict our claim purely to the non-pecuniary losses in the amount claimed, and you then have a very candid explanation as to the reasons why the common law claim was not pursued in the confidential
I do see
advice of the
that,
court.
and it's not so much, I think, that I wasn't suggesting anything in the nature of bad
No, no.
faith, but it all makes perfect sense, I think, in the context of this. I'm just thinking more widely,
Yes,
because the other thing about non-pecuniary losses is that, to me at least, they don't necessarily only mean pain, suffering, and loss of immunity.
yes.
Or damage to feelings, or whatever you might call it in a different context. They could also include loss of parental services is an example, perhaps. The loss of a parent's support when you're going through your education may be damaging to you because you do less well in your education. I'm not thinking of the financial consequences of that, but just your sense of self-esteem and your ability to achieve and make the most of your life. I think that's a non-pecuniary loss, which could be down to the loss of a parent.
Well,
But I don't think
I
that's
think
what
that's-
anyone meant here.
I don't think that's what we meant here. I mean, the difficulty with common law is, of course, you've got to have an actionable injury. But I don't.
You do see
my lord,
that. It's a long time since I've. That sort of thing that I've mentioned, you do see in general damages, as head of general damages, when people have lost a parent. Don't you? Perhaps you don't do them very often these days either, but
I'm sorry
well,
not to be able to.
there's a risk of going too far off piste. I just wanted to float this in case either of you wanted to make anything of it.
Well-
I see your basic point here. It's called non-pecuniary losses, and you basically say that's what it is.
It's non-pecuniary losses. It's set out how we got there in very transparent terms in the correspondence and in the advice. The award reflects a Strasbourg award for non-pecuniary losses. I mean, one can anticipate if someone says, well, we've settled our case and it's £250,000 all for non-pecuniary losses, for breach of Article 2, the authority may raise an eyebrow and ask for an explanation. But that's not this case. The settlement is at a level in which there could be no suspicion that it's a device in order to avoid recoupment.
Yeah, thank you.
My fifth point is that the lack of transparency in both how we calculate non-pecuniary losses under the convention and also the lack of transparency about what makes up the bereavement awards makes the assessment of the extent of double recovery very difficult. Now, it's to a degree, if one's a trial judge in the position that Mr. Justice Green was in, that can just be dealt with by the normal judicial tools. One takes a view, one's reaching an overall equitable result anyway under the convention. That's easy enough to cater for. But here we've got the authority seeking to recoup monies. And it's only got an entitlement to recoup monies that properly are compensated for already. And insofar as there is a lack of transparency, that inures in our respectful submission against the party seeking to recover sums. Because unless there's transparency and real clarity about precisely what is being sought to recover, what is double recovery, and thus why the power under paragraph 49 can be exercised, there would be a risk of arbitrariness in its application. And that takes me to my sixth point, which is, in our respectful submission, the court should be slow, absent greater clarity as to the CICA award, as to working out what the actual double recovery is here, and seeking, the court itself seeking to identify the appropriate deduction.
even if you've got greater clarity about the CICA award, that wouldn't really get you home because you still have the uncertainty at the other end of on the other side of the equation.
Well, it gets the appellant home in my respectful submission, because the problem is that of the CICA. Unless they can identify precisely with clarity what it is they say they can recover, what the element of double recovery is, they shouldn't be allowed to recoup the monies. If you're claiming money off, you're claiming off property or money off an individual under reported colour of law, you've got to be able to identify precisely what that amount is and your ability to do it.
So really, you're saying this opacity, whether it's opacity on both sides or only on one, basically means they shouldn't get a penny, even if we thought there was an element of grief in there. I mean, there might be two approaches, mightn't there? There might be approach one. There is an element of grief in there, but we don't know how big it is, and we're not going to get a suit be arbitrary, so you haven't proved your case. You can't get anything back. Or we will take the smallest possible thing we think could be attributable to grief, and you can have that amount back, but not any more. Are those really the two possible approaches?
Well, you could, to argue against myself, you could take a more maximalist approach, which is to say we're perfectly satisfied that the £5,500 is absolutely for grief.
Oh, well, sorry, yes, but that, yes, I see.
And that at least £5,500 of the £10,000 is also for grief, and say therefore they're entitled to recover that amount.
Yeah. Okay.
But for the reasons that I've sought to develop, in our respectful submission, the court can't have that degree of confidence. And that's a problem for the authority, not for the appellant, because it is the authority who's seeking to recover funds. Under a clause that to date it has misapplied.
So the court, you say, couldn't have that degree of confidence that at least £5,500 worth, so approximately half of the £10,000 probation award related to grief, or to bereavement, however we care to define that.
My lady, no, because not in the context, in my submission, not in the context in the case in which the breach is not about the death. The breach, the case, is all about the antecedent failures. In which they are of a fundamental right that requires compensation in and of itself, we say, and in which you can identify with comfort that grief would be a component of that. There's no dispute about that.
So it must be, I mean, there's a circularity to your argument. I do understand that you start from saying what you're marking is the fact of the breach, antecedent to death, and it's freestanding and it's got its own impetus. But if you accept, which I think you must, that grief can form part of a convention award, that necessarily links with the consequence of those breaches, which was that a death occurred and has left this child without a mother. And it seems very artificial to separate that out, because I mean that is what happened. That's the impetus, isn't it, of these Article 2 breaches, is that they had a disastrous consequence.
Yes, but
Not direct consequence, I'm not saying that, but in a convention sense, they led to something.
yes, it reflects why the freestanding obligation, when it arises to prevent death, is enforced. It's about the importance of enforcing those rights. But it doesn't turn the convention case for an indirect victim case into a case about the death itself, unless it's a state agent who has carried out the killing.
No, well, we're not in that territory.
We're not in that territory.
Now, I'm just wondering about the sort of practicality, or whether it's a bit artificial to be splitting up these convention awards into many different heads, when that's precisely not what the Strasbourg court does. It just, I mean, it's an unhappy phrase, but it just says, we've used it in a domestic context, but it just seems to say, look, here is just an award, a dollop, an amount. We can't make it right again, but just to represent certainly the moral, the moral upset as the consequence, because of the breach itself, but also an element to reflect what
Yes.
then happened.
But my lady, of course, see the force of my lady's point. But what one can't extract from that is saying, well, that award therefore is effectively a grief award,
No.
or it crosses over with that which
the opposite and say it's not a grief award. It is to some extent.
it has a component.
Yeah.
But the difficulty we face is that here's a provision in the scheme that permits the authority to recover sums. And in order to do that, the need for clarity as to what it is and their entitlement to it rests on their shoulders. And my submissions are that the court could, of course, in this case, say, have a go. But in our respectful submission, the more appropriate outcome, or certainly the one that would be our primary invitation to the court, is that you start from the proposition that the authority has misapplied in this case. It's the paragraph, and that vitiates its decision.
How is it misapplied? The authority hasn't done anything yet. It's just made it.
Because it's taken account of something that's related to the death.
Yes,
rather than-
it's sought to recover the entire. It's not seeking simply to recover.
Oh, I
the
see, but it
5,000.
hasn't. It hasn't.
Oh, no.
It's only in its arguments it's misapplied. It hasn't actually
If-
done anything.
no.
But it hasn't. It can't.
Well, it sent a decision letter saying we'd like it sent a decision letter saying
Yes,
we
I
are.
see. Okay, yes, okay.
So
No, you're right. Thank you.
so starting point would be that decision is vitiated because it misunderstood its powers. If the court is going to clarify that the paragraph means a double recovery rule, and that there will be elements within the Article 2 that cover it and some that don't, it's then really, in our respectful submission, a matter for the authority to seek to justify any further attempt, to make, if they wish to, a further attempt to recoup, and to justify the basis on which they do it, both as the principle, but also as to amount and why.
By way of fresh decision.
By way of fresh decision.
So that's, I'm sorry, I've got that, yes.
Sorry, that's entirely my fault. It's the second thing I've mangled today, but
no,
that's
no.
the that would be our primary submission, which is if this is a public authority seeking to recover funds, it's really for them to try
That sets
and,
up a rather unfortunate situation, doesn't it? It's cumbersome, not very cumbersome, but they have to make a fresh decision. But more to the point, they are having to make an award. I mean, just remind me, where did this? We're looking effectively at, well, they could try and argue that the sum of the 22,000 was fraud. Or they might only focus on the 5,000. I mean, they could do various things, shouldn't they? They could say the whole of the amount that we have the whole of the amount you've been paid is comprised within the overall amount we paid you. Sorry, I'm being very slow here. Or they could say it's confined to the 5,500, or they could seek to split up the 5,500.
well, I would invite the court, as well as clarifying that paragraphs 48 and 49 deal with double recovery,
Yeah,
no more,
yeah.
no less, to also clarify that even if in common law there might be a loss of parental services that can go into an award, there is no analogue in the convention award. So that therefore that can't be recovered
Yeah, okay.
out of the £10,000.
So really, you're asking us to decide, you would like to decide that the most it could be is 5,500.
Yes. Yes.
And it's really for them then to say, well, of that 5,500, 3,000 doesn't matter, just taking 3,000 as a round number, was attributable to to the same thing as you were being compensated for by the 10,000.
Yes. And in our respectful submission, that might be thought the more appropriate way, because it's the authority's claim, that might be the more appropriate way than the court seeking to.
Hard for them to do that dispassionately. As it happens, the sums here are very small, but we must look at it in principle. they would have an interest to maximise the amount which effectively they were retrospectively attributing to an award they made.
Well,
Is the 5,500 a conventional sum? Sorry,
it's a conventional sum if there's more than one bereaved.
Yes, I see. So
Just, seems to me, we may be running ahead a bit, because after all, Ms Webb hasn't even had the chance to address us on this, so we may be getting a bit ahead of ourselves. But if it were to be the case that we were persuaded that double recovery was the core of paragraph 49, there would then be a question about whether any part of the keeper award represents double recovery of the convention award. And I take your arguments, and let's say we ended up focusing on the 5,500. The question for CICA or for us might be whether the 5,500 as a proportion of the 10,000 convention claim represented double recovery with what CICA thought it was paying for, namely bereavement. That's the question, isn't it?
Yes.
There may be an issue about who gets to decide that. I'm not entirely convinced that we have to send it back to CICA, but it may be I'll get there, I don't know.
Well, the reason why would suggest that you do is there's one further step it would respectfully submit in that reasoning, which is can the court conclude at this stage that the 5,500 is all about the same type of grief that is also being compensated under the Article 2?
we might, I agree, we might not, but I mean, it's not impossible that we might take the view that really you're entitled in this area to use fairly large labels. The label 5,500 is bereavement, which is, if whatever exactly it means, is the same as at least £5,500 worth of the HRA award.
Yes, well, in those circumstances, I entirely accept the court would want to just say that, and that would be the outcome.
The ordinary procedure, it's one thing for CICA to say what their own payment reflected. It's another thing for them to have to start forming their own view about what the HRA award or settlement reflected.
Yes, I accept that, my lord. But if in fact CICA's position was of that 5,000, some of it represents the very fact of death, and £2,500 represents the grief, then in an Article 2 case about the death of a young person's mother, it would be most unlikely that one would challenge that.
Okay.
But when it comes to over half of the award for non-pecuniary damages, there's a proper basis in our respectful submission for querying whether or not that would be beyond what is necessary to ensure no double recovery. Yes.
Okay.
If the Article 2 claim came first, would the court adopt the approach that Mr. Justice Green adopted? In other words, taking into account prospectively, because you would know, because you look at the tables and be able to say, this is what the award will be. I'm going to take that into account and award an amount that I do not consider to be constitute any element of double recovery.
Yes, my lord, so long as the principle of my primary case, that this is only about double recovery, so long as that's the principle, that's the governing principle. I'm not sure there has been, I'm just trying to rack my brains as to whether or not that would arise. Because the court can only award, if it's dealing with either an Article 2 case or a private law case, the court can only award that which is recoverable under those principles. Whether or not there would be other residual sums that could be gained, that couldn't be gained in those proceedings, but could be gained in an application.
I've got lost from it. What exercise are we doing?
It's the reverse of D.
Yeah.
So in other words, if you had so it's permissible to do it if you've got the compensation claim first, but not if you haven't.
Well, I just don't think it's a matter of fact that would ever arise, right, because you would claim everything in your civil claim unless there was some discrete element of loss, or you just.
But
I'm sorry, I'm not.
The risk of, just so that I'm behind everyone else, I'm sure. If if what had happened first was the settlement
Yes.
and £10,000 had been awarded for non-pecuniary Article 2 losses, and CICA were then deciding what to do, their standard position, well, let's make it easy for ourselves and suggest there was only one dependent. So the amount would be whatever the tariff,
11,000.
£11,000. So they say, we will award £11,000. But he's already had £10,000 for Article 2 non-pecuniary losses. And we might take the view that totally overlaps with the 11,000 we were about to give her, so we'll only give her 1,000. Or they might take the position that an element in that, say half of it, represents what we were going to give her, so we will only give her £6,000. That's what they'd have to do, isn't it?
Yes,
on
that's
your
the,
analysis?
that's the procedure effectively under paragraph 48.
And I haven't looked at the provision, but even with the tariff amounts, you can reduce them if they've already been paid by someone.
You can under 48.
Yes, that must be right. So the point I was putting to you, it's very difficult for CICA to have to decide what an award made by somebody else represents. They'd be faced with in any event in that situation.
In that scenario, they will still have to make an evaluation.
And that comes back to the point that puzzled me before. Was Justice Green right, actually, to award an amount that took into account the amount that had been paid under the compensation scheme, which
Yes.
he clearly did?
My lord, he was entirely right, because his lordship identified that he would only take it into account to the extent that would otherwise offend the principle of double recovery.
No, I understand that, but he thereby is circumventing the provisions of the scheme, which would otherwise, if the full amount had been awarded, CICA would have been able to reclaim that same amount of double recovery.
Well, I'm not sure because obviously he wasn't governed by the scheme. I'm not sure that he, in any sense, circumvented it.
Okay, that's
but
a pejorative word.
But no, but quite accurate in a sense. But on CICA's analysis, on their broad analysis, they would still be entitled to come back.
You mean because even if somebody else has said,
Yes.
well, yes, wouldn't that be? And that's why it was bringing me back actually ultimately to the order. Because if the order says this isn't any element of double,
Well, I would love to be able to rely on the order, but I don't think I properly can, because it's an approval order,
yes, not a considered judgment.
not a considered judgment. There's only all the court had on this issue was that contained in a confidential advice from the
I think what you
appellant's
can see from
solicitors.
the questions, what we're trying to work out is how actually this is going to work out in practice,
Yes.
depending on the sequence and how the court should respond, whether it should adopt the Mr. Justice Green approach and say, I'm going to award an amount that takes into account what you've got, or does that risk, as you say, CICA coming along and saying, well, we don't mind what the court's done, you've still got this amount of damages and we're going to seek to recover what we consider to be.
Well, the problem won't arise, in my respectful submission, if the paragraph is interpreted as we contend, which is no more than avoiding double recovery. Because in those scenarios, a judge, as per Mr. Justice Green, will seek to take account of those areas in which there is overlap, and the job will be done.
Right, okay. So even though CICA won't be bound by it, you're saying as a matter of practice they wouldn't seek to go behind it?
Yes, because there's been a judicial process in which account has been taken of it.
I mean,
The
a real
problems are-
purist might say CICA ought to be asked to come along and if they're going to be de facto bound by the result, they should be given an opportunity to make representations, because his view of what the amount that was involved double recovery might be different from theirs.
Well,
I think, but the formal answer to that would be if they really cared enough, and if we were dealing with huge sums of money, which we never will be, they could come along and say, I know he took into account only the element that he thought was double recovery, but we actually think he should have taken into account a larger amount, and we want when we want to take back the difference,
Yes.
that would occur in a separate hearing. In the real world, that'll never happen.
It would,
But it's just so we can play out
of course.
conceptually, that's the right approach. Isn't
It is the right approach, but those sort of problems.
He wasn't quite entitled, could have, I suppose, an interested party appealed in D, could have come in and said, I mean, we see appeals like that quite
Yes.
often here, where parties aren't involved at first instance, and then one of the public authorities says, hold on a minute, you've just decided something that's completely contrary to my interests, I want to be heard as a party on appeal, and they could have appealed Green, J in D and said he got it all wrong.
Yes, and
They couldn't have, but suppose there hadn't been an appeal, so that wouldn't be open to them to appear as an interested party. They would have to have been joined in the original proceedings, or they would have to bring separate proceedings after and say, we're not bound by the result and we want
Maybe that's more
a larger
realistic.
chunk.
that may be, but I think my respectful submission, the more likely scenario is that where a judge has carefully considered the degree of overlap, taken account for it in a reasoned judgment, that sort of scenario is very unlikely. It's much more likely if judges think, hang on, I've accounted for double recovery, but the authority think they have a far wider power to recoup all of it. Well, I need to know what they're going to do
Yeah,
because I might have to add on
But
some
let's
manual damages.
assume you've won on that.
Yeah.
So we really only are talking about double recovery. I'm not saying you have won on that, but it just the argument becomes much more complicated. If I think we've probably done that to death, haven't we? I mean, it's important. I'm not sure. Speaking to myself, I decided what the answer should be, even subject to Ms. Webb. But I think we've been over the ground.
Yes.
It is important.
But just if I may, I think I may be at risk of just repeating the answer I gave to my lady a moment ago. I think in circumstances in which, as per Mr. Justice Green, there is acknowledgement of the potential for overlap, for double recovery, and that is expressly factored into an award, then it's most unlikely to produce a raft of satellite litigation. Because, and one can test that, because we know the powers that the authority have thought they have had for some very long time. And as far as we're aware, there's been no challenge to any decisions made by judges that seek to, whether in a Human Rights Act case or a private law case, seek to come back and say, no, you've got it wrong, or to our knowledge have come back and said to an applicant, we want some more money. I know the judge did it, but we want some more. So it might be a problem that's a fascinating one to think through, but in reality may not arise, and certainly doesn't bear upon the correct interpretation or approach in accordance with the submissions I've made. My Lord, I think I've incorporated all my other points in the answers that I've given to your questions, and unless there are any other matters on which I can assist, those are the submissions on behalf of the appellant.
No, thank you, Mr. Herman. That's been most helpful. Yes, Ms. Webb.
Thank you, my lords, my lady. So, in terms of a roadmap, I'd plan to address you, and I still plan to address you on the two main issues that I say are in this case. Firstly, what is the correct approach to interpretation of the CICA 2008 scheme? So in other words, rolling up points from grounds 1 to 3. And secondly, what are the nature of non-pecuniary awards in claims brought for breach of Article 2 European Convention on Human Rights under the Human Rights Act 1998, in particular by indirect victims, so bereaved relatives. So I propose to just pick up on a couple of documents in the supplementary bundle in terms of the facts of the case, and then I will address you on those 2 points, hopefully incorporating some of the things that have been in discussion as we go along. I propose to deal lastly with grounds 5 to 6 in fairly short order. Ground 5 is the effective remedy point, and I've addressed you on those in my skeleton, so I'll speak briefly to those. So just then, in terms of the facts of the case, just putting the legal arguments and analysis in the factual context, my learned friend has already taken you to some of the documents. Just in terms of the CICA award itself, you were taken to the breakdown at supplementary bundle page 5, and you've seen there you've got a fatal tariffs award and a loss of parental services award pursuant to paragraph 42A of the 2008 scheme. So just some remarks in relation to those, the loss of parental services award, if I may, but possibly coming back on that tomorrow morning. So loss of parental services, it's right, it's not defined in the scheme, but we can see from the scheme itself it's something different from financial dependency or physical dependency, as that is covered in paragraph 40 of the scheme. And if you'd like me to take you to that, then I can do so. Just
So
brief.
different from loss of financial dependency and
Or physical dependency.
yes.
So while you have a what's been flagged as a bereavement award at paragraph 39, you then have the option for some additional compensation where a claims officer is satisfied that the claimant was financially or physically dependent on the deceased. So that's paragraph 40, subsection 1. And paragraph 41 goes on to set out how the amounts of compensation are payable in respect of dependency. In other words, on a basis similar to a loss of earnings claim where the victim of the criminal injury is still alive, and paragraph 35, 1D, little Roman numeral 3, cost of care. So it's it looks to have a clear parallel with a standard approach in a common law claim, multiplier, multiplicand, case-by-case basis. So paragraph 41 has some detail as to what sorts of things the claims officer will take into account, and it's looking at the particular qualifying claimant situation.
So when you say not financial or physical dependency, I know that's the terminology in paragraph 40, but the 42A is loss for the loss of that parent's services. Now, services is a very odd word anyway to use in respect of a parent.
Yes.
But what do you say it's directed to?
Well, so it's not in the bundle. There is a scheme guide that I can just read out what the scheme guide says. It says it is an amount of money to provide some small recognition of the tasks parents carry out for their children, and it may be on top of any amount for dependency.
Doesn't say what sort of tasks.
That's the note I have. I can double check that this evening.
Since it doesn't really matter because it's a tariff amount.
It's a
So, yeah,
tariff
I mean,
amount.
yeah.
So I
But
think
it's not emotional, it's tasks.
it's the words emotions don't appear in that scheme guide. It's tasks, but it's a small recognition of the tasks.
Yes,
I
yeah.
suppose it's not it's addition to a cost of care.
Because cost of care would come out as financial or physical dependency. wouldn't it?
Yes.
So like the cost of getting somebody to look after a small child, you deal with it as financial or physical dependency.
That's my understanding. That's my understanding. I think what I'm saying is this is a tariff award, that it's, if you like, its own animal. It's not identifying a specific pecuniary loss. It's recognising the absence of the family member. So
I think that does have a common law analogue, doesn't it? When you have a fatal claim, we would generally put in a head for the fact that, you know, your mother's not there to put you to bed and read you and look after your education. Those sorts of, or your parents, sorry, I don't mean to
yes.
genderise it, but it's that sort of non-pecuniary contribution the parent makes to their child's well-being.
So my and again, I can double check this evening. My understanding is that for a schedule of loss and a fatals claim, you would present a financial loss of loss of care, and that may be the cost of getting a new carer in, someone else to carry out concrete tasks. But then there is a practice of awarding some sort of uplift or lump sum that can be categorised as general damages, to reflect the fact that it's not the same when it's not your parent.
It's
or
the sort of thing
deceased
both my lady
carrying
and
out
I have
the-
been referring to, isn't it? Help with homework, reading you in bed, all that.
So I think what I do want to be
Sorry,
careful.
pause there, but it's something
Yes, of course.
distinct from grief. It's not the same thing as bereavement, obviously.
Well, we can come to how we define bereavement, but if you'd like me to address you on that
No, I don't want to take
directly,
you out of seat. I'm just in my head trying to get straight what these different streams are.
I suppose I would just I'll make one point and then come to that. I think what I do want to make clear is that obviously, while you can try and find parallels or similar types of awards or concepts that exist in common law or even on a statutory basis, the CICA scheme is different. It's a scheme of last resort. It stands back and it has its own concepts, and you apply the words of the scheme. So while I don't wish to, I'm not submitting that paragraph 42A is exactly the same as that sort of uplift in a general damages sense, because this is a different scheme. But what we can see from the scheme wording itself is that paragraph 40 deals with financial dependency, physical dependency. Paragraph 42 deals with something else, and the CICA's.
I see that. Well, I sort of half see it, but I would be a bit surprised if the scheme, of course, with all sorts of differences, one being you've got tariff amounts.
Yes.
Though truthfully, in the King's Bench division, you have what are pretty much like conventional awards of various headings. But still, it is different in the detail, but the broad heads are intended, aren't they, to replicate the sort of the heads you would get in the common law courts? In a way, it'd be surprising if they weren't.
Well, it would be surprising if, again, I can take instructions on the purpose. I don't have at my fingertips exactly the rationale for each and
Well, I'm
every
not
thing,
asking-
but I would say, sorry,
Sorry, no, go on. Do go on.
I would say that it would be surprising if CICA came up with entirely new types of things that might
Right.
crop up either when someone's injured or someone dies and their relatives are left behind.
Anyway, sorry, we distracted you from what the points you were making. You were taking us through the scheme and just.
I was, yes, and I think just briefly on that point my lady made in terms of grief, bereavement, my respectful submission is that my learned friend's been characterising bereavement too narrowly as grief. Bereavement is about the loss of a relative, and that can be expressed by reference to death, by reference to their loss. I think grief, narrowing it, the idea of bereavement to grief is if that was the thrust of the submissions, is too narrow an approach.
Well,
So
I don't want to push my ideas on you, but have you had a chance to think about my suggestion that bereavement in this context might mean the same as it means in the Fatal Accidents Act award, which I appreciate isn't defined, it just says you get paid an amount, but as the thinking behind that.
I haven't reached a concluded view. I think my starting point, my lord, would be that bereavement is a straightforward word, and it doesn't require actually a particularly, it represents the loss of
Okay, thank you.
of a relative.
And the general thrust of your current submissions are we've got to be careful about trying to look for analogies somewhere else because this is a free-standing scheme.
Yes, I think.
So it might reflect in some way, but don't look for stray comparisons or anything else.
I think I would agree with my learned friend in that they may be of some assistance, but that you have to treat these things warily. So the CICA scheme is its own scheme, it's a scheme of last resort, and I'll come to why that matters in terms of paragraph 49 or 48 and 49. So I think I was doing a diversion into the nature of parental services as part of my summary of the facts of the case. So just then picking up a couple of other points, if I may, and forgive me if this has already gone over ground. So S7 is the acceptance slip whereby the appellant's grandmother accepts on behalf of her granddaughter.
So sorry, what?
So sorry,
What is it?
page 7 of the supplementary bundle.
Oh, I see, sorry, yes.
I'm sorry, I've
No,
flagged
no, that's fine,
myself
I
as
just know what you
S,
meant.
but
I've got it. Yep.
and we can see first paragraph, it's the sum is expressed to be in full and final settlement of an application for compensation due to the death. And then third paragraph is all about understanding that the authority will have to be repaid from any damages, settlement or other compensation which may be received in this respect. I'm not saying pay attention to this rather than the wording of the scheme, but that was the understanding on which this award was accepted. I think my learned friend's taken you to the letter of claim already, and I think it's clear that the nature of the Article 2 claim was a breach of the operational duty under Article 2 by all 3 defendants. There was a separate claim by AXO in relation to Article 3, which is helpful to note insofar as some of the wording of the Upper Tribunal has been criticised in comparing and contrasting those two the Article 2 and Article 3 damages. And then just in terms of the without prejudice correspondence, the schedule of loss that I believe you've been taken to, that starts at, bear with me, page 53 of the same bundle. Paragraph 1 says this schedule of loss sets out the claimant's losses arising out of the death of the deceased. It includes both pecuniary and non-pecuniary losses, talks about the claim of each of the claimants for non-pecuniary losses under the Human Rights Act, and paragraph, I think you've been taken to paragraphs 10 through to 30, which sets out AXO's claim, and obviously the Human Rights Act damages in issue in the appeal are at paragraph 30, so it's 10,000 for Article 2 and 5,000 for Article 3. But just to flag, paragraph 31 sets out a further claim claimed on behalf of the deceased's estate, also in relation to Article 2 and Article 3 claims. I believe we've already we've looked at the solicitor's report. Page 69 is outlines liability under Article 2 ECHR. So paragraph 24 sets out when there will be a finding of a violation of the operational duty. So the Osmond test, which incorporates the idea that a failure to take preventive measures might be expected to avoid the risk to life. So there is within that, it's not that those measures are irrelevant to the outcome. They were had a potential to affect the outcome, and that's again covered at paragraph 26 on the same page, to establish causation, and therefore an entitlement to damages for a violation of Article 2 ECHR arising from the death of their loved one or relative is not required to establish on the balance of probabilities, but there is nevertheless a requirement to show a lesser causal link, a substantial chance or real prospect. So there is a test. It's lower than balance of probabilities, but it's there nevertheless. There were, in terms of the frank discussion of the difficulties with the Article 2 claims on behalf of AXO, that's at page 71. There's a heading, application of these principles to the present case, and there's a discussion of difficulties with liability, but also causation, paragraph 36. The defendants may also be successful in their arguments, but the claimants will have difficulty in establishing causation, i.e. whether any acts or omissions made a material difference to the outcome. So just pausing there, this is because an article, this Article 2 claim and claims by relatives, you need to show this connection between the breach and the outcome, in this case the death, in order to be
So,
entitled
and
to
to what point
damages.
does in your submissions does this go?
So I think the CICA contends that the Human Rights Act damages were in respect of the death,
Yeah, I see.
and that's because there has to have been a death for the indirect victim to have had standing. You need this causal connection between the breach and the death for a finding of liability, and I'll come on to how the courts approach Human Rights Act damages and make an award of damages in these cases. I think the reason to draw this out on the facts is that this was a case where the allegation was that the breaches of Article 2 had a causal link with the death. So the case was in relation to the death. And the key paragraph I think the Upper Tribunal flagged is paragraph 63, and I think we've looked at that. AXO settlement is clearly not for services of financial dependency. £10,000 for a breach of Article 2 ECHR, i.e. to reflect the loss of life, the mother's loss of life, the defendant's failure to protect that life, and then goes on to talk about the Article 3 damages. And just pausing there, nowhere in this case paperwork is there any identification of separate harm or loss suffered by AXO in relation to Article 2 that's not related to her mother's death. So this isn't obviously a case involving failures in police investigations, attracting, with discrete psychiatric injury or upset. And finally, the CICA correspondence concerning recoupment is at pages 82 and 88. And the only reason to flag these to you is the wording is not requiring payment of the Human Rights Act damages. It's requesting an authorization to deduct the same sum from the account held by CICA in AXO's name, i.e. To the extent some of the wording suggests that CICA is going to receive the damages themselves, it's seeking recoupment of its own award. It's a slightly
It's put
pedantic.
the award in account for the child, hasn't it?
Yes.
And what it's saying is we're going to take a chunk out of that and restore it to our own coffers.
Exactly, and the whatever was done in terms of the settlement of the Human Rights Act damages claim, whether that was a payment into court or whatever, that sum is untouched. So in terms of
But
that-
that, sorry,
yes,
just
yes,
for
of
my own
course.
clarity, man, that doesn't really matter, does it? I mean, it looks worse, I suppose, presentationally, to say we're going to take some of your damages, but it's all money at the end of the day. It doesn't actually affect the legal analysis, whether they're going after the damages or simply reducing the amount, which simply because she's not yet of age, they happen still to have under their control.
I suppose financially it may have the same outcome for AXO, but I think so. Just in terms of the issue of remedy, AXO, whether or not she's received an effective remedy, the sum paid out, that it matters in terms of who's had to pay out money, and just to cut through to the short point I'll make in terms of ground 5, the defendants in this case, she brought her case.
Is ground 5 the
against them.
A1P1 ground?
It's that's
which
ground
is.
6.
I'm
So
sorry.
ground 5 is the CICA's, just to paraphrase horribly probably, the CICA's interpretation denies the claimant an effective remedy, but CICA's position is she's had her remedy. She's had a declaration or admission or letters of apology or the form of settlement with those defendants who she says were in the wrong, and they've had to pay out money, and that has not been disturbed by CICA's approach.
It's because of that remedy, excuse me, that the CICA is entitled to recoup the amount from the account.
Exactly. Either the CICA is right about grounds 1 to 4, or we're wrong. I don't think that the grounds 5 or 6 get matters further, but it is important that those defendants have paid out a sum in what's contended to be just satisfaction damages to AXO. She's had her remedy from the relevant defendants. Turning to then the issues of statutory interpretation. So obviously the key issue is whether the CICA award and the Human Rights Act damages payment were in respect of the same injury. Just stepping back in terms of the principles of statutory construction, there were a number of authorities in the bundle all about statutory interpretation, but I've cited Colfax in the skeleton argument. My submission is that encapsulates the correct approach here. So you have a starting point, the ordinary meaning of the words used. Secondly, don't try and fit the statutory scheme within confines of some analogous legal context. And thirdly, construe the scheme both in context of it as a whole and with due regard to its evident purpose. So my lords, I've set out in my skeleton why CICA considers the Upper Tribunal got it right in applying the ordinary meaning of the word used. The grounds of appeal made certain assertions in terms of that analysis, so I can take you through it in detail, but I don't know if we're now stepping back from the Upper Tribunal's precise wording and just talking in broad conceptual terms instead. In terms of my skeleton argument, where I've gone through the relevant, just the exercise the Upper Tribunal engaged with, that's at paragraph 17, and it's on page 27 of the core bundle.
Sorry, which paragraph did you say?
Yes, of course, paragraph 17.
Yep.
And so that's my submission in summary, and of course happy to take you through it if you wish.
You characterise at little e on page 28 the Upper Tribunal's determination that it was a question of fact. The Article 2 settlement was paid in respect of the death. It's not really, is it? It must be a matter of law, mixed law and fact. It must be. What Article 2 damages are paid for.
You may be right, my lady. I suppose the point is CICA will look at each case individually. So some Article 2 claims may involve, for example, failures in post-death investigation, which may raise additional matters. On the facts of this case, the position is the Article 2 settlement sum was paid in respect of the death. So we've got breach of operational duty, a causal link, albeit lower than a balance of probability test with the death, and then an identification of the death in my submission as the key harm.
I think I'm just asking you whether you'd accept a proposition that I put to you, which is that what the Article 2 money is paid for in this, and I suspect in the other cases, at least a question of mixed law, in fact, because you have to understand the scope of Article 2 and the reason why the damages are paid, and then look at the facts of the case. So it is amenable to appeal. I mean, we can look at it.
Yes, of course. Yes, of course.
And then the other thing was on little f, page 28. You talked about whether the Upper Tribunal was entitled to conclude. I think this is probably a case where they were either right or wrong. It's not an entitlement to conclude. It's not an area of discretion in the case. It's whether they got it right or wrong in their interpretation of paragraph 49.
So then they were. We would say they were right. And as part of the Upper Tribunal's analysis, it it noted the dangers of attempting to gloss this phrase "in respect of," and in my submission gave it its natural meaning. Perhaps I could take you at this juncture to section 1.1 of the 1995 Act, which also uses that same phrase. So it's on page 20 of the first authorities bundle.
What am I looking at? Sorry.
So paragraph 1, subsection 1, the Secretary of State shall make arrangements for the payment of compensation to or in respect of persons who have sustained one or more criminal injuries. And
Yes, well, it does use the phrase "in respect of," but in a different context.
it's, yes. But what we can see from that phrase is it allows the scheme to encompass and provide payments to not only those who've sustained the injury themselves, but qualifying relatives.
But that's not an issue, is it?
Well, I don't know whether it is an issue or not. The issue was taken with the Upper Tribunal's analysis, and CICA say the Upper Tribunal was right to say, even though AXO was not the direct victim of the criminal injury, and thus the payment was not seeking to directly compensate her for what her mother experienced, nevertheless, the payment to her can be said to be in respect of...
I didn't understand Mr. Hermer
Yes.
to whatever might be taken out of the original grounds. I didn't understand Mr. Hermer now to be saying that because it was an indirect victim, the recoupment provisions didn't apply.
Okay. I think then I will move on to say it makes sense when considering a CICA payment for AXO it makes sense to identify the relevant injury as her mother's death. I believe that was taken issue with in the skeleton argument. And my submission is that's again a common sense approach to the scheme, whereby a fatal injury can be understood, compensation to qualifying relatives can be understood to be in respect of the death of their relative. It's the same thing as saying in respect of the fatal injury. And if you're with me on that, and the CICA position then is that the Human Rights Act damages are also in respect of the mother's death, as the reality is they reflect the bereavement and other impact experienced by the family member.
Sorry, reflect bereavement and other.
Well, impact because of the loss, yes. So all the different headings under the scheme allow for various impacts, but they all relate to the death of the family member. So you've got the bereavement award, you've got the fact that the mother isn't there to provide the parent services. That's the paragraph 42 damages.
Well, section 2 sets out how the what compensation is payable under an award, and it sets provision shall be made for a standard amount of compensation and then additional. So the structure of the scheme is dictated obviously by the terms of the Act.
Yes.
So as you say, you make a claim for a payment of compensation, provided within the scope of it. That compensation is to be calculated as provided by the scheme in accordance with section 2.
Yes.
And then 3(1)(c) permits the scheme to include provision for the whole or any part of any compensation to be repayable.
Yes. Exactly.
So the focus throughout is on the compensation.
Exactly. The focus throughout is on compensation, and it's victim focused. Those who've sustained injuries or have been affected by such an injury.
Sorry, go on.
Yes. So I'd say section 1(1) of the 1995 Act is relevant to that, and then it's broadly worded. You've the focus is on compensation. Section 2(2)(d) you went to, it obviously defers to the wording of the scheme as to additional amounts that may be specified in cases of fatal injury. And section 3(1)(c) you've just flagged does not purport to limit the circumstances under which an award received from CICA there is to be repaid in full or in part.
What you are repaying is the compensation.
Yes.
So that
So
and obviously there has to be some reason why you're repaying the compensation, rather than, say, repaying a sum that you've received for some other reason or something else.
So
Why is it? What do you say about the structure of 1, 2, and 3, or 3(1)(c)? Does it reflect the convention, or?
well, I say section 1, subsection 4 defines compensation. It's simply quite circular. It says compensation means compensation payable under an award, and the specified circumstances are to be provided in the scheme, and the scheme as a scheme of last resort, it is all about repayment of any payment, the full value of any payment in respect of the same injury.
Where are you reading
So-
from now?
So that's section 48(1), which.
Paragraph 48. yeah.
So sorry, paragraph 48(1).
Have you moved on from the Act?
I don't think there's much more to be gleaned from the Act, if I may.
Because what I wanted to ask, the Act, excuse me, is intended to implement or reflect the ratification of the European Convention.
Yes.
So that includes Article 9 with, sorry, I'm sucking a sweet to try and stop myself coughing, which is why I keep stumbling. With a view to avoiding double compensation, the state or the competent authority may deduct from the compensation awarded or reclaim any amount of money received and compensation, etc. So double compensation, how do you say that article or the wording of that article impacts on the interpretation of the provisions of the 95 Act?
Yes, so Article 9, and I will address you briefly on Articles 1 and 2.
Sorry, I didn't want to take you out of your course.
No, not at all. Let me go direct to that because that's clearly the thing to do. Article 9, you've got broad wording. So firstly, with a view to avoiding double compensation. So that's the intention behind it. But what it goes on to say, the state or competent authority may deduct any amount of money received, not specified to be compensation, in consequence of the injury or death from the offender's social security or insurance or coming from any other source.
What point do you make? Are you saying that the convention would allow a member state to have legislation which allowed it to recoup anything that wasn't double compensation or couldn't properly be regarded as double compensation? That can't be right, can it? Or perhaps that's not what you're saying.
So that's, bear with me. I think the difficulty, while that's the intention, how it works in practice is difficult, where you've got a scheme of last resort, which has its own concepts within the scheme in terms of different elements of an award. And then on the other hand, you've got different types of civil claims. So the CICA would say you've got tort claims, you've got convention claims, which are going to be in respect of the same injury, but there may not be an exact line-up between the different items within
But
them.
all that means is that it may sometimes be difficult to decide what is double compensation. That's why we're here.
Mm.
I suppose what this is really coming to is I'm perhaps picking you up too early in your submissions, which haven't quite matured on this point, but it's not very terrible for you if we say that the Act is intended, that the Act and the scheme must be construed in such a way only as to allow recoupment for double compensation.
Mhm.
You still run all the core arguments in the case saying there wasn't double compensation in what you were seeking to recover. But I rather got the impression that you were seeing, we can, if necessary, go further than recouping double compensation. And that would be, I think, a surprising submission if it was your position.
I think, my lord, I know what you say. I think the difficulty is what does double compensation mean? What does double recovery mean? Because it seems that the argument now from the appellant the fallback argument is in terms of like for like heads of loss, and actually the reality and how the scheme
Well,
works.
I agree.
Isn't.
I think there are, obviously, it's very important to decide what is and what isn't double compensation, and those sort of questions will arise. But I still think it's helpful to identify the overall principle as one of avoiding double compensation. And I don't think it's terribly damaging to you if that's acknowledged, even if the argument seems to have gone a slightly different way in the Upper Tribunal.
Yes, so I think, my lord, I would say that that's certainly the intention, and we can see from the convention, Article 9, it's all with a view to avoiding double compensation. But also in this convention, you can see there's a lot of deference to states as how they undertake to carry out these principles. That's paragraph, that's Article 1. There's also there's deference to the administrative arrangements. So we can see that, I think that's the commentary to Article 1 in terms of the explanatory report. Bear with me. It's page 12 of the bundle, basic principles. So the parties are undertaking to ensure their schemes comply with the convention, and it's for the contracting states to establish the legal basis, the administrative framework, and the methods of operation of the compensation schemes, having due regard to these principles. So yes, while there's going to be an overarching principle of avoiding double recovery, how that works in practice, that states have a lot of latitude, and it needs to be administratively workable. And some, I think, of the submissions in terms of CICA trying to stand back and identify what a Human Rights Act damages award may be subdivided into, in my respectful submission, is not going to be a workable approach.
Yeah, thank you. Sorry, we distracted you by taking you off into the convention.
Quite right. So quite right to do so. So I think other just broad points in terms of the wording of the Act, just to points I had to make.
But it's still on the Act.
Well, I just yes, I just briefly just to say there's nothing to indicate that. So paragraph 38 on page 17 of the bundle, of the authorities bundle.
The explanatory report to the European Convention.
Again, so that second paragraph, it is for the parties to specify which sums are so deductible. So yes, a broad principle of avoiding double compensation. But the question is, what does that mean in practice? And in terms of a narrow identification of double compensation or double recovery in terms of heads of loss, insofar as that's being argued for, the CICA position would be one would need to stand back, because that's not how what's required by the convention, and we've got very broad wording at paragraph 48 of the 2008 scheme. And just to flag, in the bundle there's an authority called Woodcock, which I can briefly summarise, tell you what it concerns. That's probably relevant to slot in here. It's not a Human Rights Act damages claim. It's
Do you want to, are you just to summarise, or do you want us to go to it? Up to you. I'm not asking to be taken to it. Just want to know whether I should.
I think it's probably better if we go to it, please. It's at tab 25. the reason to take you to this is that it is it's I would say a recognition by this High Court judge, Justice Ritchie, that criminal injuries compensation scheme awards will be deductible from civil damages received in a civil claim against the police, and it's a case concerning.
Sorry, just
Yes.
why is that material?
So I think to the extent that there is an idea that CICA would, what damages is CICA entitled to recoup? So this is civil damages obtained in a case against a state body, the police, and the case is all about failures to protect from an attack. And what I will go on to address you on is in terms of how actually there isn't that there is such substantial overlap between damages in a civil claim and in a Human Rights Act damages claim in terms of what's being compensated. There's no logical reason CICA shouldn't also be entitled to recoup Article 2 damages.
Was there a particular passage you wanted to take us to?
Yes, so
Where?
thank you. So it's at paragraphs 109 and 110. So it's at page 1016.
Shall we read those?
Yes, please.
I have a hunch that this is on appeal, isn't it, this case? No.
I hadn't identified
Anyway, it doesn't
that as
matter,
being
for
the
the moment
case.
it stands as is.
Okay.
But it's quite a well-known, created quite a ripple at the time, isn't it? Para 101, did you say?
109 to 1110.
It's really just the last sentence of 110, isn't it? Or
Yes.
thank you. Yeah, where we go now.
Thank you. So I had prepared some brief talking points on the appellant's nuts and bolts issues with the Upper Tribunal wording. I suppose I'll address you on the what was characterised as the meta point, which, as I understand it, was that the Upper Tribunal adopted an approach whereby it's sufficient for CICA to identify, or for there to be some connection between settlement and criminal injury, or where the settlement has arisen from a broader course of conduct where the underlying criminal injury formed a part. So this idea that some connection is sufficient, and my short point is that Upper Tribunal were right ultimately to find that both the CICA award and the Human Rights Act damages award were in respect of the same injury and didn't apply a lesser test, if you like. And it may be that submission was born of the fact that the Upper Tribunal contrasted the nature of the Article 2 damages with the nature of the Article 3 damages, and I can take you to the paragraph. But my short point is that the approach the Upper Tribunal applied, and it was that damages of both payments were in respect of the death of AXO's mother. I think what is relevant to pick up and flows from all this is, well, what are the nature of the Human Rights Act damages?
Sorry, can you speak up?
I think I would need to turn to what are the nature of Human Rights Act damages logically,
Yeah.
then at that point. So bear with me. What I'd like to do then is propose to deal with this heading under 4 headings. Firstly, the court's approach to non-pecuniary damages in Human Rights Act claims generally. Secondly, in terms of court's approach to such awards in Article 2 claims brought by bereaved relatives. Thirdly, applying it to this case, and fourthly, mopping up any points on authorities relied upon by the appellant. So I do wish to address you on DSD and the most recent case, the Irish case that's at the back of the bundle. So turning then to the first heading, the general approach to non-pecuniary damage generally, I'd like to take you to Greenfield and the ECHR practice direction, and I will also address you in terms of moral harm under this heading, I think, because that's moral harm or
That'd be
moral
very
injury
helpful.
that's cropped up in discussion. So Greenfield, first of all, that is in the first bundle. It's tab 10, and the relevant discussion is at 316. Page 316. So this is where there is an authoritative discussion by Lord Bingham of the nature of just satisfaction, and comes on to, it's in broad terms, and then he goes on to the damages in terms of Article 6 claims, but I will just briefly go through the section. My lords, I was going to take you, and my lady, I was going to take you to paragraphs 6 through to 16, well, missing out paragraphs 10 and 11 that are less relevant, and 19, I don't know if you wish to read them or you're familiar
Well,
with them.
let's do that. Yes, thank you. So leaving out which one? Sorry, 10 and 11 and 9, 10 and 11
10 and 11, I think.
and 17 and 18. So sorry, which paragraph did you say?
So sorry, so
That's my fault entirely.
6, paragraph 6 is general, 7 to
Do we
7
need
to 9.
7? It's all about Article 6, isn't it?
Well, it is, but my lord, it discusses the relevance of causation for that article because it contrasts with
don't worry.
others.
We'll read it all.
Thank you.
Well, speaking for myself, I have rather skim-read most of it because it's there's a lot of detail there, and it's really all about Article 6. But I have carefully read Article 19, paragraph 19. I don't know whether my lord and my lady have
It's getting
taken the same course, but
My lord, Jen, just briefly drawing,
well,
making some
no,
brief.
with-
I'm so sorry.
That's fine.
yeah, thank you. Yes.
So paragraph 6 deals with the general points and the role of for just satisfaction, a payment of damages to be made. There needs to be a breach. Only partial reparation according to domestic law, and an award must be necessary. So pausing there must be examples where domestic system already provides for full reparation. Paragraph 7, I appreciate it's Article 6 damages, but it does say, it discusses the relevance of causation for Article 6 cases, since unlike other articles such as 3, 4, 8, it does not follow from a finding of a violation of Article 6 that the outcome of the trial process was wrong or would have been otherwise had the breach not occurred, i.e. There are
Well,
the point being, perhaps the last paragraph of that sentence of that paragraph is helpful here. There's a risk of error if Strasbourg decisions given in relation to one article of the convention are read across as applicable to another. So
that's why I was
and that-
wondering why all this Article 6 stuff. Article 9, paragraph 19 was very helpful,
Yes.
but sorry, I don't want to move you on if there are points you want to make on those intervening paragraphs.
I suppose, I think there is a careful discussion about causation and identifying damage. There's a discussion, I think, when it comes to the question of what is moral harm or moral injury, some of the cases that are relied upon by the appellant or concern other types of articles, Article 3, Article 5, then I say are relevant for this type of Article 2 claim. So the Article 2 claim we have before you isn't a case of the state wielding fatal force. It's not a disappearance case. It's not the state arbitrarily detaining someone, the state torturing someone. It's a different sort of case. So I would. It's not necessarily so straightforward to say, well, this concept of moral harm exists and it goes over and above an identification, a need to identify or infer damage, such as upset distress. There's something additional to that. If that's the submission by the appellant, then I'd say actually there's a danger in reading across from other cases that sort of principle. If that assists. That's the general approach then in terms of Article 6 damages, but it is reflected then again in the practice direction by the European Court. That may be a more helpful.
Well, I'm
resource.
wondering whether this might be a good moment to call a halt. Losing 10 minutes isn't going to make a difference. You'll be comfortably finished in of course tomorrow.
Yes, of
Early
course.
tomorrow
Yes,
morning,
yes,
I
yes.
expect we're making reasonable progress. Good. Well then, 10:30 tomorrow. Thank you very much indeed.